Hello and welcome to Runkle to the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. So if you've been following the Taking Care of Maya case, there have been 4 orders that have just dropped. And we're going to go through them, and there's a little bit of spice in them. That's part of why I think they're so much fun. The judge is running out of patience, and it shows in these orders. So let's have a look. Most of them are fairly short. One of them is a little longer. So the first one we'll look at is this one. Order denying defendant J. Hatch, so that's Johns Hopkins All Children's Hospital, motion for a new trial based on alleged juror misconduct. They said that juror number 1 was engaged in shenanigans, and the court said, no, you haven't proven that. So before the court, following hearing and juror interview, is defendant Johns Hopkins All Children's Hospital, who we're just going to call J. Hatch. Motion for juror interview, motion to open discovery into evidence of juror misconduct, an emergency motion to preserve evidence. J. Hatch supplemented this motion 3 separate times in writing. That's unusual. Normally you'd file a motion and it's filed. It's weird that you'd be keeping on coming back to it, and this is the beginning of where the court's going to point to things being a little weird. Plaintiffs responded in opposition. On December 15th, 2023, the court conducted a non-evidentiary hearing on the motion. On January 3rd, the court conducted a juror interview of juror number 1. So that was on lots of channels, and basically J. Hatch got nothing. And at the end of it, the judge concluded that J. Hatch had not proven anything. So because J. Hatch failed to demonstrate any juror misconduct, the court denies the motion. And we're going to go through how and why it was denied. So J. Hatch raised in its motion and supplements many issues concerning juror number 1 that J. Hatch claimed demonstrated misconduct by juror number 1 during the trial. These allegations included juror number 1's alleged failure to abide by court instructions. Specifically, they said that he was instructed not to research the case or talk to anybody about the case, and they say that he must have done so based on some real thin reasoning, and we'll see that. On December 15th, 2023, the court conducted a hearing on the motion. By order dated December 20th, 2023, the court allowed a limited juror interview on 4 different topics. And this was limited in a couple of ways. 1, they were not allowed to sort of explore everything they wanted. And 2, the court was asking the questions and not J. Hatch's counsel. They really wanted a cross-examination, and the court said that's not happening. So the court determined the other requested bases for juror interview were either untimely, meritless, or both. So untimely means you should have filed it sooner. Meritless, of course, means it's garbage. And in a lot of cases, they found that they were both of those things. The court set that juror interview for January 3rd. On December 29th, they filed its motion for reconsideration of the scope of the juror interview. They said, we want to ask more questions than you're letting us ask. We want to cross-examine. We want to have access to the phones. We want all of this stuff. J. Hatch doubled down. That should be doubled down, I think. But anyway, on its claims and affirmatively and prospectively alleged without proof that juror number 1 would lie during the juror interview. We're starting to see the court is going, really? You know, you're alleging ahead of time that he's going to lie, but you've got nothing to say that he's lying. Okay, you can't just guess that. J. Hatch confirmed in this reconsideration motion that the 3 supplements were the result, in part, of investigations by pro-J. Hatch internet communities, i.e. Reddit. They went on Reddit, and lawyers, be real careful with Reddit and so forth, because Reddit can lead you to do things like file a motion where you're alleging that juror number 1 is calling one of your witnesses a Nazi because of their typography. And the court really had no interest in that argument. The court thought that was a little dumb. So internet communities that suggested that, the court had some opinions about your suggestions. On Tuesday, January 2nd, 2024, the first business day after J. Hatch filed his motion, the court entered its 14-page denial of reconsideration. So, no. The court declined to expand on the scope of the juror interview that was to occur the next day. And think about it, like, if it's going to be the next day, why would they expand the juror interview because then the other side is going to be a little prejudiced, right? The other side's going to be vulnerable on that. So that doesn't seem, that doesn't seem super ideal. So, all right. And further explained why the subjects not included in the juror interview were untimely or meritless or both. On January 3rd, the undersigned conducted, so that's the judge, conducted the juror interview of juror number 1 in open court in the presence of the parties, media, and public spectators. Juror number 1 appeared with his attorney. The court questioned juror number 1 as to each of the 4 bases identified in the court's December 20th order. Now, juror number 1's attorney didn't have to do a whole lot of heavy lifting. He didn't appeal, or, he didn't object. He didn't any of that sort of thing. So that was not, sort of, he didn't seem to be doing a whole lot, but I'm sure he advised juror number 1 of like his risk and all of that. So, all right. The 2002 case. So J. Hatch contended that a 2002 circuit court case from the 17th Judicial Circuit, Broward County, revealed a reference to child abuse and DCF, the Department of Children and Families. This was concerning to J. Hatch because the subject matter of the current lawsuit included discussion of DCF's actions prior in sheltering Maya Kowalski based on a claim of medical child abuse. So, because juror number 1 said no, and they say that the answer should have been yes, that they were upset by this. So the court received into evidence the 2002 docket during the juror interview. This is when we're going to start seeing some real spice starting up. The public docket in that case reveals the case was an interpersonal violence petition filed by juror number 1's then wife against juror number 1. Juror number 1's then wife failed to appear at the return hearing, and the petition was dismissed with no adjudication on the merits less than 2 weeks after it was filed. So she files a document. She doesn't show up to argue the document. She doesn't pursue it at all, and it gets thrown out. And that's the end of it. So, yeah. During the court's questioning of juror number 1 credibly confirmed that there was no involvement by DCF during that 2002 case, and juror number 1's then minor children were not taken into protective custody by DCF or otherwise sheltered. So the relevance starts to seem pretty weak here, right? He also noted that he had no opinion of DCF for the government's ability to shelter a child. So the 2002 Broward case from more than 2 decades ago does not demonstrate any juror misconduct. Now we're going to get into some real stuff where the court has some thoughts. Whether juror number 1 knew attorney Deborah Salisbury. The supplemental juror questionnaire included, among other questions, 97 names of potential witnesses. The supplemental questionnaire instructed the potential juror to answer yes or no for each of the 97 listed potential witnesses, whether the juror knew or thought the juror knew the potential witnesses. J. Hatch contends that juror number 1 improperly said no to question 74 on the supplemental. Can you imagine sitting there and there's 97 names of people, do you know these 97 people? It's really easy to be like, oh. Regarding knowledge or potential knowledge of potential witness Deborah Salisbury. Ms. Salisbury represented Jack Kowalski for some portion of the dependency court proceedings. Ms. Salisbury never testified in the trial, so she wasn't a witness. She was just sort of tangentially connected. As presented in its written motion, J. Hatch reached the conclusion of alleged juror misconduct based on an unidentified 2007 domestic relationship proceeding filed in Sarasota County involving juror number 1's current wife. The written motion did not provide more detail. I'm guessing this might be Reddit research here. During oral argument on the motion, J. Hatch affirmatively represented to the court that Deborah Salisbury was juror number 1's wife's attorney for a divorce proceeding, the same attorney that represented Mr. Kowalski. Now, when you are a lawyer and you make a representation to the court, that representation to the court had better be accurate. It's got to be truthful. When you are telling the court a fact, you have an ethical obligation to make sure that fact is true. And if something comes up and it turns out that that fact is not true, you have an ethical obligation to correct that. So as an example, if a client of mine tells me that they have a job and, I later determine that they don't actually have a job, that the client lied to me, I would actually have an obligation to correct the record and be like, no job. So it's a big deal. When you make those representations, you are doing so as an officer of the court. It's important. And you don't want to be the sort of lawyer that gets a reputation for representing things that are not true. Your word in court is everything as a lawyer. And if you're not able to make representations to the court and have the court believe them, you are in some serious soup. So, with that in mind, on to what the judge has to say. Prior to the interview, Deborah Salisbury filed an affidavit in which she asserted J. Hatch's allegations were false. Whoops. Ms. Salisbury stated that she never represented juror number 1's current wife in any capacity whatsoever. She advised the court docket from juror number 1's current wife's 2005 divorce proceedings from her former spouse demonstrates on the face of that docket that both parties in that case were self-represented litigants, i.e. no one had a lawyer, so she couldn't have been the lawyer if no one had a lawyer. In other words, neither party had an attorney in the divorce proceedings, and that is an objective fact easily discernible from the docket of that dissolution of marriage case. Objective fact easily discernible is the court saying, why the hell did you represent a fact to me that is not a fact? Why did you spew BS in my courtroom? Judge is unhappy. Unhappy judge. Ms. Salisbury attached the 2005 docket to her affidavit, which J. Hatch should have done. And the court concurs with Ms. Salisbury's observation concerning this objective fact. This is understated in the way courts usually are, but this is the sort of thing I would be reading with an absolute sinking feeling in my stomach if it was talking about me. Ms. Salisbury further stated that in 2007, she was appointed by a family law judge to represent an individual in a 2007 domestic relation proceeding. Ms. Salisbury discussed in her affidavit that she attended a brief hearing in that 2007 case where juror number 1's current wife may have been present. Doesn't seem like she knows. Ms. Salisbury's role in that proceeding was not to represent juror number 1's current wife. Instead, her representation was adverse to juror number 1's current wife, i.e., if anything, she was on the other side of things. So Ms. Salisbury further attested that no one from J. Hatch contacted her to inquire about her alleged representation of juror number 1's current wife. You're alleging facts and you haven't even done basic stuff to confirm those? Please tell me you didn't just rely on Reddit, because if I was a judge and this was what was determined and they said, well, we trusted Reddit, I would put as much weight on that as, well, I trusted GPT or Chat GPT. In the current case, J. Hatch has done nothing to clarify its position with respect to Attorney Salisbury, retract any representation, or to dispute Attorney Salisbury's affidavit. Now, this is going directly to that ethical obligation I mentioned. When there is if you've said something and it's not true, you have an ethical obligation to correct it. And certainly if I had filed something and then the attorney says that's not true, I'd either want to cross-examine that attorney on it, like if I thought that that attorney was lying or wrong or something like that, or I'd retract it with an apology to the court, like, sorry, I thought this was the case. I had good reason to think it was the case. Here's my good reasons. But we no longer think it's true, so we're not arguing that point. So, during the juror interview, juror number 1 testified he and his current wife married in 2016. He also testified credibly, so 2016 is a long time after 2007, right? He also testified credibly that on September 14th, 2023, when he filled out the supplemental juror questionnaire, he did not know attorney Deborah Salisbury. There's no evidence juror number 1 even knew his current wife in 2007. That's 9 years later. I can tell you, if my wife had hired a lawyer 9 years before I met her, the odds that I would know the name of that lawyer are vanishingly small. Like, I don't know who she knew 9 years prior to me marrying her. Yeah. J. Hatch's claim that juror number 1 knew Ms. Salisbury is meritless. There's no evidence of juror misconduct on this issue. And what the judge has hinted is that there might be some evidence of lawyer misconduct on this issue. Again, if I was the lawyer, I'd be really feeling bad about this. Watch juror number 1, or whether juror number 1 spoke with his wife about the case during trial. J. Hatch attached to its motion several internet postings made during the pendency of the trial about the trial that J. Hatch attributed to juror number 1's wife. J. Hatch, I mean, do you really want to be a juror in a high-profile trial if it means that the other side is going to be stalking your wife? This is kind of gross in and of itself, especially because it's such a fishing trip. So, I mean, if I was juror number 1, I'd be pissed that they were stalking my wife. J. Hatch also attached a screen grab from the broadcast of the October 30th, 2023 trial date depicting juror number 1's wife sitting next to an individual J. Hatch contended was pro-plaintiffs and who appeared on various internet shows that were reporting on the trial. I sat in the gallery of the Depp trial, and I can tell you I sat next to all sorts of people, some of whom were pro-Depp, some were pro-Heard, and it was just because I was sitting in places. Like, who you're sitting next to doesn't mean a whole lot. While J. Hatch contended that the contents of juror number 1's wife's posting suggested there were communications between herself and juror number 1 concerning the trial, the court disagreed that those postings led to that conclusion. For instance, juror number 1's wife posted prior to the testimony of Detective Graham that law enforcement juror number 1 would have questions for Detective Graham. As the court previously explained in open court, anyone following the case knew juror number 1 was a retired law enforcement officer and that juror number 1 was asking questions of most witnesses. So how hard is it to figure out that he's going to have questions for this witness when he has questions for every witness? Not hard. If you've got a dog that bites everybody, you're pretty confident when you say, don't go in there, the dog's there, the dog will bite you. It's not that you had communication with the dog. Sorry about the analogy there, but yeah. Juror number 1's habit of asking a witness multiple questions was predictable. Perhaps not as certain as death and taxes, but nearly certain, such as a traffic backup on I-4 near the Disney Champions Gate area. An internet post suggesting juror number 1 would have questions for a witness, including a law enforcement witness, did not unfairly or remotely suggest discussion between juror number 1 and his spouse. When the court starts getting sarcastic and jokingly sarcastic about how they are dismissing your arguments, that's a bad thing as a lawyer. You want the court taking your arguments seriously, and when they start venturing into even gentle mockery, you're in unhappy territory. There were other posts too that J. Hatch contended shows communication, but in context of this case, have innocent explanations and do not suggest inside or knowledge or improper communications with juror number 1. Nothing about the content of those questions suggested to the court that juror number 1 was speaking to anyone, including his spouse, about the case, i.e., you've been on a giant fishing trip. So, whether juror number 1 obtained information about this case, J. Hatch also contends that juror number 1 violated the court's repeated instruction not to investigate or receive information about the case outside of the court. And I just want you to, like, bask in awe at the audacity of this particular argument. Specifically, J. Hatch contended that on October 9th, 2023, juror number 1 used the term creature comforts in a question to a witness. J. Hatch identified a screenshot purportedly from Dr. Anthony Kirkpatrick's website that contains the phrase creature comforts. Based on this happenstance, J. Hatch leaped to the conclusion when you're trying to support a motion like this, you don't want the court concluding that you are leaping to conclusions. that juror number 1 was performing an investigation outside of court. Plaintiffs in their response observed that on September 28, 2023, a witness in open court before the jury used the same creature comforts phrase, because plaintiffs were doing a lot better groundwork on these motions. Like, plaintiffs were going through the jury questionnaires and were able repeatedly to point out that J. Hatch had failed to object to things, so plaintiffs did a lot of groundwork and legwork on this one, and I give them tremendous credit. Given juror number 1's habit of taking copious notes and referring to them when formulating his juror questions, plaintiffs posited that J. Hatch's theory is unsupported. I might have gone a step further and just said, like, creature comforts is a pretty common term, and that's where the court goes. Despite the innocuousness of this phrase and its common usage in our lexicon, the court permitted a juror interview on this topic, i.e., even though we thought it was BS, we let the question be, we asked the question. And juror number 1, of course, credibly testified that he didn't investigate and didn't review the webpage, and so there's no evidence. So, on all of that, having reviewed the motion and supplements, listened to oral argument, and conducted a juror interview, the court finds juror number 1 did not violate the court's instructions or otherwise engage in misconduct. J. Hatch has failed its burden to demonstrate any juror misconduct. Accordingly, the court denies J. Hatch's motion for a new trial based on alleged juror misconduct. So that's number 1. They lose the mistrial application, and then and the court's got some spice. The court's got some things saying like, really? You told me this person was his wife's lawyer. That doesn't appear to be true. Are you sure you wanted to tell me that? Now, if you think that counsel for Johns Hopkins is having a bad day, it gets worse. Their day gets so much worse. And let's move on to their day getting worse. Order on post-trial motions. I said something before about you don't like it when the court starts getting dismissively humorous. Let's expand this a little bit. When the court gets into poetry, that's even worse. When the court starts writing like an epic poem, you should be a little more concerned. So here we go. Pain more intense than childbirth. Pain more intense than kidney stones. Pain more intense than amputating one's limb. The worst pain imaginable, the degree and intensity which most of us cannot comprehend. Pain so intolerable that the condition is nicknamed the suicide disease. This was but a small portion of the evidence presented to the jury concerning the pain associated with a condition called complex pain regional syndrome. Maya Kowalski contended at trial that she has CRPS and had CRPS when she presented to Johns Hopkins All Children's Hospital. Johns Hopkins disagreed that she had CRPS, and the jury was presented evidence that healthcare providers at Johns Hopkins believed she was faking it. And there was evidence that Johns Hopkins treated her, or more precisely, declined to treat her accordingly. Ooh, you already know this motion is not going to be in favor of Johns Hopkins. And indeed, it's order on post-trial motions. They haven't told us where they're going yet, but you get the feeling, right? The jury learned this failure to treat CRPS will increase the number of, severity of, and duration of future CRPS flare-up episodes Maya will experience throughout her entire life. In other words, there was evidence that Johns Hopkins, by its conscious indifference, sentenced Maya to even more extreme debilitating pain that she will have to endure throughout her entire life than she otherwise would have had Johns Hopkins correctly treated her. The judge's gloves are off. Throughout this trial, the judges played his own opinions very close to the vest. And now we're hearing the judge saying, you guys screwed up so bad. How dare you? How dare you come to me with this? I mean, they basically sentenced this girl to a lifetime of torture. And that's what the court is saying. So let's see how they reduce the numbers here, because that's what Johns That's what Johns Hopkins is asking for. There can be no question the jury credited Maya Kowalski's version of the evidence, and the jury rejected Johns Hopkins' claims that it provided Maya with exceptional, compassionate, and heroic care. They might have agreed that the care was exceptional, but not in a good way. The jury rejected Johns Hopkins' belief that it was Maya's savior. There's some snark. The jury found that Johns Hopkins, on at least 3 separate occasions, falsely imprisoned Maya Kowalski, and Johns Hopkins, on at least 2 separate occasions, battered Maya. Johns Hopkins management knew about this intentional misconduct and directed it, condoned it, and ratified it. Johns Hopkins also intentionally inflicted emotional distress upon Maya, yet Johns Hopkins continues with its quest to immunize its conduct, even though that conduct does not remotely result from its call to the DCF abuse hotline or its participation in the dependency court proceeding. This is the court saying, you need to understand, you are the villains. You are the villains in this story, and you need to understand that and recognize it and start acting like you are sorry for that. The jury was also presented with evidence concerning Johns Hopkins' egregious treatment of Maya Kowalski's mother, Beata Kowalski. Based on that treatment, the jury found that Johns Hopkins intentionally inflicted emotional distress upon Beata Kowalski that resulted in her death by suicide. So, they file a 144-page motion entitled Renewed Motion for Directed Verdict, Motion for New Trial, and Motion for Remitter. Remitter is basically when you say the jury awarded too much money, and because they awarded too much money, the court needs to dial it back and pull some of that money back. And I'm going to tell you now, Johns Hopkins is going to win on some of that. They're going to get some money dialed back here, but they're not going to get what they ask for. So an overarching theme of Johns Hopkins' motion is it did nothing wrong and its actions were rather ordinary. The jury rejected that view of the evidence. In its motion, Johns Hopkins either ignores or minimizes ample evidence of its misconduct. Having sat through the entire trial, the court rhetorically wonders what Johns Hopkins' definition would be of an extraordinary action. The court is tired of your bullshit. The court is saying, what the hell are you thinking, writing what you're writing? There's no doubt that the various monetary awards by the jury are significant. Being large, though, does not necessarily mean they are excessive. In almost all cases here, they are not. Where they are, the court has remitted the excessive jury award. So the court is saying there are a few places where we are going to dial it back. And they say just because the court remitted a few jury awards, it does not follow that the entirety of the jury verdicts were improper or the product of passion. They were not. The reader should not lose focus that this case was qualitatively different than most other cases in terms of novel issues, the juxtaposition of a dependency court proceeding, immunities, the vast number of disputed evidence, the parties' conduct in 2016, 2017, and damages sought, disagreements between counsel, length of verdict form, and consumption of judicial resources, just to name a few. So basically what this paragraph is this is the court saying, I know they're going to appeal this, and I know when they appeal this, they're going to point to a bunch of other cases that they say are similar. And here is a paragraph to say why this case is unique and this case is different and special. So, the jury invested 2 months' time listening to complex and often very contradictory evidence. They were attentive and engaged during trial, and they asked many questions, many questions. They deliberated for 2.5 days in the first phase of the trial. Despite the picture painted by J. Hatch's motion, this jury did not go off the rails. I like that the judge is defending the jury because the jury had a very difficult task in this case. They had to deal with very weighty issues that they're probably going to be remembering. I think some of these jurors are going to lose sleep over what happened to Maya and her family. So After nearly every jury trial, the court will thank the jury for their service. The work of juries is very important. We should treat them with some respect. Right, J. Hatch? So the scope of J. Hatch's immunity. So first they were arguing that they should be protected. They shouldn't be able to face any of this money because of immunity provided by Florida statutes, which they say cover virtually all of its actions while Maya remained at J. Hatch during the dependency court proceedings. This included J. Hatch's decisions without input from DCF or the dependency court. That's kind of, the court saying, hey, you're wondering why you're outside of the immunity. Here's a hint. To place Maya in a video surveillance room to confirm whether her actions are consistent with CRPS or are instead consistent with a psychological problem that may have been caused or enhanced by her mother's behavior, as well as removing Maya's clothes to document her skin condition before she left for court. Parenthetically, note here J. Hatch's downplaying of the evidence to suggest that its actions were benign, contrary to the jury's construction of J. Hatch's actions. I.e., the jury found that you were the bad guys. Stop pretending you're heroes, because you're not. You're the bad guys. And the first step to not being the bad guys is to realize that you have been the bad guy and to adjust course and to make amends. J. Hatch has no explanation why, if these actions were taken for medical reasons, Maya's medical records are not littered with reports, observations, photographs, and other contemporaneous notes documenting what was being done to Maya. If it's for medical reasons, you wouldn't be keeping it secret. And the results of those tests. Certainly, the jury was presented with evidence and the lack of medical records explaining the necessity to place a commode just outside of Maya's reach and then intentionally delaying in coming to help her use the restroom, causing her to defecate on herself. So basically they wanted to show that she's faking it. And to show that she's faking it, they put the toilet so she couldn't get to it. And when she was saying, hey, I need help to get to the bathroom, they just intentionally didn't show up, figuring, oh yeah, she's going to use the bathroom and then we'll have her, we'll know, right? Except it didn't work out that way. And she was, as a result, humiliated. And now she's got to be in court telling the world that this happened to her. If stripping a child and taking photographs was done for medical reasons, where's the concurrent medical record evidence? These are but a few of the cruel acts for which J. Hatch seeks immunity. If you're photographing a child naked for non-medical reasons, maybe jail. This feels like jail. This feels like be glad that your punishment is being meted out in dollars and not years. Because I feel like years is the appropriate term for some of that. So skipping ahead a little bit, there's some discussion of good faith and that. We're going to skip that. On the one hand, J. Hatch objected to and heavily criticized any effort plaintiffs made to introduce matters that occurred in the dependency court proceeding. On the other hand, J. Hatch repeatedly attempted to litigate the core claim from the dependency court that Beata Kowalski committed medical child abuse on Maya Kowalski and that Beata Kowalski suffered from Munchausen syndrome by proxy. The court, though, had already ruled J. Hatch immune from all claims that otherwise resulted from its agents reporting the suspected abuse, i.e., you can't be punished for the dependency court stuff. Despite the court's trepidation during trial, and the court believes the trial transcript will demonstrate, the court routinely allowed J. Hatch to provide substantial and likely cumulative evidence and testimony concerning J. Hatch's theory that Beata Kowalski suffered from Munchausen syndrome by proxy, because it gave context to how Maya Kowalski presented to J. Hatch in October 2016, and it had some probative value on the wrongful death and survivor claims, i.e., even though we didn't want to, even though the judge didn't want to do this, the court says, we gave you so much leeway in this. Plaintiffs objected to the court allowing this, to the point where plaintiffs often complained J. Hatch was using Chapter 39 as both a sword and a shield. So we went so far that the other side was up in arms about how unfair it was. And even though it might have been unfair, you still lost, J. Hatch. So after it is all said, though, even under J. Hatch's requested more generous scope of immunity request, the reality remains. J. Hatch battered Maya Kowalski on at least 2 separate occasions, which actions do not otherwise result from any Chapter 39 action J. Hatch took. That last part is repeated in all of these. So J. Hatch falsely imprisoned Maya Kowalski on 3 separate occasions. J. Hatch intentionally inflicted emotional distress on Maya Kowalski. J. Hatch intentionally inflicted emotional distress on Beata Kowalski. J. Hatch submitted fraudulent bills. J. Hatch committed medical malpractice on Maya Kowalski. Does that sound like the heroes of the story to you? Not to me. Consistent with its "we're protecting the mandatory reporter" theme, J. Hatch continues in the motion with its sky is falling public policy argument. The court is so tired of their BS, which is more appropriate for the legislature. I.e., if you got a problem with this, take it up with government. And they will. J. Hatch has all the money to hire lobbyists. You can better believe that they will go to politicians to say, this can never happen again. If we ever harm a child the way Maya Kowalski was harmed, that we need to be protected. We need to be immune from that. Push back. You may need to contact your representatives if you live in this area to be like, this is BS. So if this judgment is not set aside, no hospital in Florida will be willing to keep a child in DCF custody in its facility once the child is ready to be discharged to foster care. The court does not understand J. Hatch's embrace of that public policy argument without reference to its egregious conduct this jury found J. Hatch committed. You want to paint yourselves as the heroes. If you want to make this argument, you need to do it in light of the fact that you were horrible. And if you can't make that argument in light of the actual facts the jury found, which is that you were horrible, then why should I entertain it? This is one of the things about when you've got a weak point of your argument, you have to engage with it, because otherwise you may end up looking ridiculous, which they do. So the next issue is the addition of time. And basically, I'm going to summarize this one. I had some more things I wanted to talk about on this one, but I'm going to summarize it because it's less interesting. Basically, plaintiffs asked for 100 hours per side. J. Hatch asked for 60 hours per side. The court went to 55 hours eventually, which is really close to what J. Hatch wanted. And later, they awarded each side an additional 4 hours based on the many questions the jury asked. Jury had lots of questions. He's like, jury's eaten up a lot of time. We're going to give 4 more hours for each side. So we're now at 59 hours when J. Hatch asked for 60 hours. So he also notes that he offered to allow J. Hatch to recall any of the witnesses who had already testified if they had additional questions. Like if there's something that you didn't get to that you needed more time for, call that witness back. You can do that. They didn't accept. And if the court offers something to fix a problem and you don't accept it, and then you say, but it's a problem, later on the court's going to say, but you didn't take the chance to fix it. So that's on you now. So J. Hatch also, there were also offers of, if you guys need more time, we can give you more time. And so the court says the court cannot agree that J. Hatch was prejudiced because the case went to the last day the court announced to the prospective jurors in September. And summarizing this, the court says, if time truly were to become an issue for either side, the court would have trimmed days off, trimmed the length of arguments, worked earlier and longer, and otherwise would have addressed what they said they truly needed. And if truly necessary, the court could have extended the trial the following week as a last resort. But you never asked. The party would have had to discuss the issue in real time with the court to give the court an opportunity to address whatever the issue claimed to be. You didn't ask, so you can't complain about it now. I would have given you more time if you needed more time and you asked for more time. So Maya Kowalski's intentional tort claims. So there's a sort of summary of numbers here. Put into their separate claim context, these numbers do not reflect J. Hatch's contention of an unbridled jury that ran amok. The jury's restraint is particularly observable in the 3 punitive damage awards, which J. Hatch also challenges. The punitive damage awards do not exceed the statutory caps established by the statutes, even though the jury made findings to permit them to be exceeded. The jury said, the caps don't apply here because your actions are so egregious that the caps are busted out. But even then, they came to a number that was within the caps, even though they could have picked any number they wanted, basically. And given how pissed off the court seems to be about Johns Hopkins' behavior, do you think that he's going to find that the jury was being unreasonable in picking big numbers? I don't think so. Notably, J. Hatch in its Phase 2 evidence and closing argument convincingly and effectively communicated to the jury that every dollar awarded as punitive damages would be a dollar unavailable for important cancer research or charity care, including care in Sarasota County. This argument resonated with the jury. So, carrying on here, recall there was evidence, among other evidence, that J. Hatch purposefully moved a portable commode just out of Maya's reach and then intentionally declined to help Maya in a timely fashion, causing her to defecate on herself. And there was more similar egregious evidence at trial as to this claim. Confusingly, J. Hatch contends that this process was not actually treatment of Maya Kowalski. It was primarily a non-invasive diagnostic test. If you made me crap myself, I would be very annoyed at you calling it a non-invasive diagnostic test. This was a running problem for J. Hatch during the trial. Either it was performing a medical procedure, or it was not, and J. Hatch was never clear and definitive with that quandary to the jury. If it were a medical, and I think that the reason why they were never clear is that they didn't want it pinned down, because either way they try to pin it is bad for them. If it were a medical procedure, there should have been copious contemporaneous discussions about it in Maya's medical chart. Similarly, if it was a diagnostic test, it should have gone into the chart. The jury heard and saw evidence there was not. And while J. Hatch says there's evidence she was not imprisoned in the EEG room, whereas here there is disputed evidence, it is up to the jury to resolve the conflict. And then this is a line that should resonate. And I really hope J. Hatch and J. Hatch's counsel hears it. As it relates to the battery finding for hugs, kisses, and petting, no means no. The court has no patience here for J. Hatch and their effort to reframe this as anything other than shocking and egregious conduct. And quite frankly, I think Johns Hopkins, when they fail to acknowledge that, really loses the court and should lose the public. There's all sorts of stuff here that I think they could have gone to jail for. So the court, though, pauses to note a paragraph at page 81 of the motion of J. Hatch's discussion of battery. J. Hatch asserts, Maya Kowalski claims that Ms. Betty told her that she would be wanted to be her mother. Assuming that testimony is true and Ms. Betty's testimony is false, that statement is not a battery and it did not involve a touching. It would have to rise to the level of extreme emotional distress to even be relevant in this case. This, of course, minimizes Maya's testimony, which speaks to the intentional infliction of emotional distress. Yet J. Hatch discusses it in the context of battery, saying the statement is not a battery, as if to dismiss the conduct in its entirety. Can you imagine how shocking it is as a child stuck in a hospital in extreme pain, being tormented like this, being prevented from seeing her mother, being prevented from the exercise of her religion, to be told, hey, here's new mommy, I'll be new mommy? Oh. I mean, the whole Johns Hopkins story could be credibly the beginning of an action movie, because I think that if you put this to an audience, like a movie audience, and the next thing involved was a parent going in, like strapping in and getting, going crazy, people would be on this, like, people would be cheering for that hero. This is a horror movie. This is so bad. So this paragraph is an artful dodge of the evidence. Again, the court is pissed off because J. Hatch then ignores the evidence that J. Hatch purposefully was trying to emotionally alienate Maya from her mother. Telling Maya her mother was dangerous, telling Maya repeatedly that someone else was going to be her mother, was wrong. The court understands that the healthcare providers at J. Hatch, to their core, believe that Maya was not safe in Beata Kowalski's presence, and the law permitted them to share those concerns in the abuse hotline report and to the dependency court. So that is allowed, right? They can decide that she's dangerous and to report that they feel that there's abuse, but they can't go beyond that. They should have kept their actions there, but there was evidence they did not. And there was evidence from which the jury could find J. Hatch's hubris in engaging in conduct to Maya's face that J. Hatch purposefully designed to destroy Maya's relationship with her mother. Now we're seeing the judge's opinions, right, on what went down. And the judge is furious. And so am I. Medical malpractice. So this is about Dr. Sally Smith. Dr. Sally Smith served in at least 2 separate capacities with respect to Maya Kowalski. First, she was on staff at J. Hatch and consulted on Maya Kowalski's case. There also was evidence that she directed Maya's care. Second, she was at the same time the medical director of the Pinellas County Child Protection Team, and at certain but not all times, was performing her statutory role with respect to assisting DCF with its dependency action. She really shouldn't have been both, right? Pick a hat. J. Hatch understandably attempted at trial to place all of Dr. Sally Smith's actions under her medical director status due to sovereign immunity, i.e. one hat is protected from any sort of lawsuit, so they're saying everything is under that hat, right? But because J. Hatch allowed Dr. Sally Smith to perform both roles simultaneously, there was no neat dividing line of her actions. The closest analogy the court can draw is a law enforcement officer conducting a statutorily required crash investigation at the same time as conducting a DUI investigation, but with no changing of hats. There was evidence from which the jury could conclude that Dr. Sally Smith was J. Hatch's apparent agent, making it liable for her malpractice associated with Maya's care and treatment. Okay, so now we're on to, with regards to Beata Kowalski. This part is difficult because this is with regards to Beata Kowalski's suicide. So the court understands J. Hatch disagrees the law could make it 100% liable for another's death by suicide based on its intentional conduct. And this is one of J. Hatch's strongest arguments on paper, but it doesn't seem to be doing so well, partially, I think, because their other arguments are so bad that it's really put the court into a disagreeing with you specifically mood. And the court recognizes this situation is rare, and of the few cases remotely discussing this situation, most are out-of-state cases. To summarize the court's view, this I think is J. Hatch's best argument on appeal, by the way. Florida law permits recovery against an actor for an actor's intentional conduct that either 1, was a substantial factor in causing the decedent's death by suicide, or 2, created in the decedent an uncontrollable impulse to die by suicide. Now, uncontrollable impulse is a tough standard, right? For a claimant to recover, the claimant does not need to show the actor specifically intended for the decedent to die by suicide, i.e. that doesn't have to be your intention, but it has to be an uncontrollable impulse or, and it has to be intentional conduct. So the jury in this case agreed both theories existed. The court does not alter its view of Florida law on this topic and declines to eliminate this cause of action, i.e. if you want to take this issue up, you got to take it up to the Court of Appeal. Court agrees. Court's not throwing out the money for that. Jury's non-economic damage award due to Beata Kowalski's death. So non-economic is pain and suffering, right? If you punch me and break my collar or my cheekbone, medical costs would be an economic thing. Lost wages when I couldn't work would be economic. But the fact that it really hurts and that I might be disfigured, those would be non-economic damages, but they still get translated into money. That's how that goes. So The jury also awarded each child $18 million in non-economic damages, and the total non-economic damage award, so Jack Kowalski got $50 million, each child got $18 million, so total of $86 million. No remitter is required in consideration of various factors, and rejects their efforts to compare it to tobacco cases because it says this is not the same as tobacco cases. However, there is one factor that does require some consideration for how to reduce the money. And so ultimately, the court says, under these very unique circumstances, the court concludes that the jury could properly award $18 million to each child, which they did, and will deny the remitter motions for those claims. The $50 million award to Jack Kowalski for non-economic damages, however, is excessive. So they're cutting down the $50 million to $24 million. So, as much as the court is annoyed by all of the arguments Johns Hopkins has made, they have just won to the tune of $26 million. $26 million has just been knocked off of this. And I will never make $26 million in my life. I'm never going to have a pile of $26 million. But that is, just something to note here. So the other thing, though, about knocking that off is that it does help protect the remaining amount, which is lots, on appeals. So jury's economic damage award due to Beata Kowalski's death. I already covered sort of what economic versus non-economic is. So as a reminder, remitter does not examine probability, i.e. what the court thinks should have been awarded, but it looks at the highest permissible range within which the jury could operate. So they are going to knock some money off of here. $18 million verdict for Jack Kowalski by $16 million down to $2 million. So they've just gained another $16 million. By $250,000, they're knocking off of Maya Kowalski's, which was $2 million, goes down to $1.75 million. And now here we've got a typo, and we'll enter into some discussion about what this typo means. The court will remit the $2 million verdict for Kyle Kowalski by $250,000 million to $1.75 million. This is what we call a scrivener's error. This is clearly a typo. It's a mistake, and it's plainly a mistake on its fact. There's another place where the judge again goes over these numbers, and it's very clear it was intended to be $250,000, not $250,000 million. And you can't deduct $250,000 million from $2 million. So what do we do about this error that's in the judgment? We ignore it. It's clearly $250,000. I don't think anyone's going to have any issue. The court will probably issue a corrigendum or something else to just say, page 13, that's a mistake. So, billing fraud. Court agrees the little more than $1.5 million in direct economic damages Jack Kowalski individually received is the maximum he could receive for all these economic damages. So the $5 million awarded exceeds the maximum possible range. So the $3 million gets knocked down to $1, and the $2 million gets knocked down to $1. So basically, that gets knocked down substantially. So conclusion. The court denies J. Hatch's motion in all respects except as specifically identified in this order. Grants certain remittent motions, so they win some things, they lose other things. Granted in part, denied in part. Denied in its entirety except as specifically granted in this order. So everything is denied except the following specific things. $50 million goes down to $24 million. $18 million goes down to $2 million. $2 million goes down to $1,750,000. Another $2 million goes down to $750,000. This is where I was talking about that scrivener's error. You can see here where he spelled it out a different way. That is great. I don't think there's any argument possible that this was not just a typo. So $3 million verdict is granted and goes down to $1. $2 million verdict is granted, goes down to $1. Pursuant to the rule, the personal representative has 15 days within which to reject the remitter and elect a new trial on damages with respect to jury questions, etc. And they can separately elect as to each remitter ruling. So what this means is that the person who had their money reduced, so that's the Kowalskis, can either accept the reduced amount of money and say, okay, fine, we'll take what we get, or they can force a new trial specifically on the money amount. And I don't expect we'll see that, because that would be an expensive new trial. And I suspect that they probably just want to see the end of this, especially because there are many, 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 many millions of dollars still coming their way. So if they don't file anything within 15 days, it's considered to be accepted, but they can decide that they accept it before then, so that the court can then issue an order entering judgment. Jack Kowalski, same deal. He has the same option. The parties shall advise as soon as possible how to effectuate set-off with respect to the Dr. Sally Smith settlement. She settled elsewhere. You can't claim twice for the same action, so that's what the set-off is. There's going to be some additional discussion when we get to the next order. This order is not the judgment or judgments and does not complete the judicial labor remaining in this case. I.e., the judge is like, I am not free yet. I am still chained to this rock. The remitter election periods have not expired, and the mechanics of set-off has not been resolved. Also, this is also telling Johns Hopkins, you're not done with me yet. You don't get to kick me off this file. You're stuck with me. After these two issues have been resolved, the court will enter the judgments, and if elected by the personal representative or Jack Kowalski individually or both, a new trial on any rejected remitted damage claim. You're still stuck with me on that. So, now the next two are going to be much shorter, just to discuss sort of what's going on. So the first of those is the court basically going, children, get together and sort your stuff out. So order directing mandatory in-person mediation. And this is the court saying, everybody's got to get together. There's a bunch of issues left for you to solve. Please don't make this be court battles. Please just work your crap out. So on the court's own motion, the court directs the parties to mediate all motions for costs or attorney's fees, or both, as well as all disagreements existing between them. Neither side really wants the mediation, because they've not had a whole lot of success in mediation, because, quite frankly, my read on why they haven't had a whole lot of success is that Johns Hopkins is still thinking they're the heroes. And the Kowalskis are like, we have a jury verdict that says you're the villains. So I don't think we're going to see a whole lot of room in this. But the court's trying. They're trying real hard. The mediation must be in person. Everybody's got to sit down over coffee and look each other in the face. For plaintiffs, Maya Kowalski and Jack Kowalski must be present. The personal representative's attendance is sufficient to represent Kyle Kowalski's interest, but he can attend if he wants. The reason why they're saying that they must be present is the judge is saying every person who is required to make a decision has to be in this room. You guys all have to be there, such that anything doesn't have to be like, well, okay, we'll make it, this seems good, but we have to take it to our people. Everything has to be something that can be decided in this room at once. The judge is tired of all of this crap and really wants them to sort it out. So for Johns Hopkins, the president or CEO has to appear, or a senior executive, as well as any other client representative. They can send other people if they want, and all of that's covered by mediation privilege, i.e. you can't use discussions in mediation in future court cases. JHHSC, the Johns Hopkins Health System Corporation, is not required to attend because they haven't asked for attorney's fees or costs, so they're not a party. So the court says, please show up if you can, but I can't make you because you're no longer a party. They say a high-level representative of each insurance carrier or entity operating like an insurance carrier that may have to provide payment must attend. We don't want a situation where it's like we have to go back to our insurance carriers. It's like, no, that person has to be in the room so that you can just go and say, deal's good, right? And also notes they must have full authority without the need to contact any other person or consult any committee. You guys have to be ready to make a deal in that room right away. If there's been an allegation of bad faith, they must have separate counsel to resolve and address any bad faith claims. And you have to give your list of people 20 days prior. They can agree to invite other people, and they, they can't do so unilaterally, and they have to select a mediator. So basically, the court is saying, children, I need you to get into a room and resolve some stuff. Please, for the love of everything, resolve some stuff. Thank you. And then the last one, order concerning outstanding sanction requests, because there's a bunch of sanctions requests, including over like missing cell phones and so forth. So as discussed, there are a number of pending unresolved motions seeking various sanctions against a party or attorney or both, as well as unresolved matters. And so the court is saying within 15 days, you have to file a list of everything we have left to deal with. I want to know everything that is left. Failure to include anything on your list means you have waived it. If you don't put it on the list, you can't argue it later. It is gone. It's dead. And by separate order, the court is directing the parties to mediate all outstanding matters. So all of your sanctions requests that you identify specifically have to go to mediation. And to be clear, the court will not address the outstanding sanction request before the mandatory mediation. The court is tired of the fighting on this one, and the court is saying, children, you've got to get into a room and try to work this out. And when I mean, I'm being a little dismissive here. And I don't think Maya's counsel are the problem. And the reason why I say that is because Maya's counsel are holding the cards here. Maya's counsel are the people who should reasonably be saying, you got to pay a whole bunch of money. Johns Hopkins seem to be the people whose position is at odds with reality, as called out by the court repeatedly in these orders. They're saying, how is it you're still trying to present yourselves as the heroes when you suck, when you're the villains, when you did such bad things, when the court specifically has to say no means no? You know what context that comes up in? Yeah. I don't want to ever be thinking of sending kids to a hospital that doesn't understand that no means no. So Johns Hopkins, get your stuff together, because the court is tired, and I think more tired of you than the other side, but still the court wants everybody to just work your crap out. So anyway, I guess that covers the orders. I think we're really starting to see the judge's opinion on this one, and the judge is so unhappy with Johns Hopkins, and it's just like, why do you guys not realize where you are, what side of the table you're sitting on? How do you not realize what you have done? And somebody who doesn't realize that or won't accept that they've done wrong when they've done wrong probably won't ever do better. Acknowledgement is an important part of rehabilitation, and I think Johns Hopkins is in a place where they really need to be looking at rehabilitating themselves. So, thank you guys for watching. I hope you found this one to be interesting or educational. A lot of people were asking me about these orders, so I wanted to cover them. I also want to thank my Patreon supporters at the $50 level: Canada's National Firearms Association, the Canadian Shooting Sports Association, CCFR, and Lembas for the Elf. I also want to thank at the $20 level Lindsay Metcalf, Larry Kalniak, Kyle Fox, Drunk All of the Baileys, Cameron Johnson, Andrew Elsich, Vicky, and Dorky Dane. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching. Hope this has armed you with knowledge. See you next time.